An LAPD officer just pulled you over. He says he wants to look inside your car. You have 3 seconds to decide what to say. Most people say yes. Most people do not know. They do not have to. Most people do not know that what they say in those 3 seconds and how they say it determines everything that happens next. This video is the information those people needed before that stop. Before we start, drop the word search in the comments right now. Tell us what city you drive in and whether you have ever consented to a vehicle search. We want to know how many Los Angeles drivers have given up rights they did not know they had. By the end of this video, you will know exactly what LAPD officers can legally search in your car, what they absolutely cannot, and the specific words that protect you in both situations. The Fourth Amendment to the United States Constitution says the government cannot conduct unreasonable searches or seizures. That amendment applies to your car. But here's what most drivers do not understand. The word unreasonable is doing enormous work in that sentence. Because over the past century, the United States Supreme Court has carved out a long list of exceptions, specific situations where police can search your vehicle without a warrant and without your permission. Knowing those exceptions is not paranoia. It is the difference between evidence being admitted and evidence being thrown out. Let us start with what they can do, because understanding their authority is the only way to recognize when they have exceeded it. What LAPD officers can legally do. Number 1, they can search your car if you give them permission. This is the most important point in this entire video. If you say yes, the search is legal. Everything they find is admissible. Your Fourth Amendment protections disappear the moment you consent. California law is clear on this. Consent must be freely and voluntarily given. Officers cannot force you, threaten you, or coerce you into agreeing to a search, but they can ask. And the vast majority of drivers, when asked politely by an officer holding a flashlight at 11 o'clock at night, say yes. They say yes because they assume they have to. They do not. Number 2, they can search your car if they have probable cause. Probable cause is a legal standard that means a reasonable person would believe a crime has been committed or evidence of a crime is present in the vehicle. Probable cause is not a feeling. It is not suspicion. It must be based on specific observable facts. Examples of probable cause in a vehicle stop include the smell of burning cannabis or alcohol, a visible weapon or illegal item in the passenger area, or reliable information from a witness or informant that the vehicle contains contraband. If probable cause exists, officers can search your vehicle without your permission and without a warrant. Number 3, they can seize anything in plain view. If an officer is conducting a lawful traffic stop and sees something illegal in your car, they can take it. No warrant needed. No consent needed. This is called the plain view doctrine, and it extends beyond sight. California courts have recognized plain smell and plain touch as well. If the officer smells alcohol or cannabis when you roll down your window, that smell alone can establish probable cause for a search. This is why what sits on your passenger seat, your center console, and your dashboard matters. Everything visible to an officer standing outside your window is effectively in plain view. Number 4, they can search your car if you are placed under arrest. This is called a search incident to lawful arrest. If an officer arrests you from your vehicle, they are permitted to search the passenger compartment of your car for weapons or evidence related to the arrest. However, and this is critical, the scope of this search is limited. Under Arizona versus Gant, a 2009 Supreme Court ruling that is still the law today, police cannot search your entire vehicle incident to arrest unless you are within reaching distance of the car or it is reasonable. To believe evidence of the arrest offense is in the vehicle, if you are handcuffed and sitting in the back of a patrol car, the justification for searching your vehicle incident to arrest generally ends. Your trunk is not part of this exception unless the officer has separate probable cause. Number 5, they can search your car if it is impounded. If your vehicle is towed and impounded, officers can conduct what is called an inventory search. This is an administrative procedure. They are documenting the contents of the vehicle for record-keeping purposes. However, inventory searches must follow standardized agency procedures. It cannot be used as a pretext to search for evidence when no other legal basis exists. Number 6, they can temporarily detain you based on reasonable suspicion. Reasonable suspicion is a lower standard than probable cause. It means an officer has specific articulable facts that suggest criminal activity may be occurring. Based on reasonable suspicion alone, an officer can briefly detain you and your vehicle. They cannot conduct a full search based on reasonable suspicion alone, but they can ask questions, run your plates, and investigate further. If that investigation develops into probable cause, the search authority follows. Now here's where the law draws hard lines. What LAPD officers cannot legally do. Number 1. Cannot search your car based on a hunch. Reasonable suspicion requires specific facts. Probable cause requires specific facts plus a reasonable belief that a crime has occurred. A general feeling that something is wrong without specific observable evidence is not a legal basis for a search. An officer cannot search your car simply because you are nervous. An officer cannot search your car simply because you are in a high crime area. An officer cannot search your car simply because he does not like your answers. If no legal exception applies, the search requires a warrant signed by a judge. Number 2. They cannot search your car because you refused. Your refusal to consent to a search cannot by itself be used as probable cause to conduct that search. This is one of the most important legal protections you have during a traffic stop. The act of saying no is not suspicious. It is a constitutional right. An officer who searches your car solely because you refused consent has conducted an illegal search. Any evidence found in that search may be subject to suppression. Number 3. They cannot extend your stop indefinitely to find a reason to search. A traffic stop has a defined purpose, the reason you were pulled over. Officers cannot legally extend that stop beyond what is reasonably necessary to address the original reason for the stop. They cannot detain you for 30 minutes hoping to develop probable cause. They cannot run repeated checks on your license hoping something comes back. The stop must be reasonably related in scope to the circumstances that justified it. If they extend the stop without additional justification, your attorney may be able to challenge everything that follows. Number 4. They cannot search areas beyond what their justification allows. If an officer has probable cause to search for a rifle, they cannot open an aspirin bottle. If an officer has a warrant to search for documents, they cannot open a locked box that clearly cannot contain documents. The scope of any search must be connected to the specific evidence being sought. Exceeding that scope is a Fourth Amendment violation. Number 5. They cannot use coercion to get your consent. Consent must be freely and voluntarily given. If an officer says you have to let them search, that is false. If an officer implies something bad will happen if you refuse, that is coercion. If an officer makes threats or uses pressure tactics to obtain consent, that consent may be legally invalid. A court can examine the circumstances under which consent was given and determine whether it was truly voluntary. Number 6. They cannot search your phone without a warrant. This is one of the most significant legal protections of the past decade. The United States Supreme Court ruled in Riley v. California that police must obtain a warrant before searching the contents of a cell phone. This ruling applies even during a lawful arrest. Your phone is not subject to the same search rules as the contents of your car. An officer who searches your phone without a warrant or your consent has violated your Fourth Amendment rights regardless of the circumstances of the stop. The 3 things to say and do. Here is the practical information. What to say, what to do, and what not to do. First, if an officer asks to search your car, you are allowed to say this: I do not consent to a search. Say it clearly. Say it calmly. Do not argue. Do not explain why. Do not ask if you have to. Simply state your position and let the law do the rest. Your refusal is not an admission of guilt. It is an exercise of a constitutional right. Second, if you believe the search is proceeding without a valid legal basis, say this: Officer, I am not consenting to this search. State it for the record. This preserves your ability to challenge the search in court. Do not physically resist. Do not attempt to interfere. State your objection clearly and allow the process to continue. Physical resistance creates additional legal problems regardless of whether the underlying search was lawful. Your remedy for an illegal search is a motion to suppress in court, not a confrontation at the roadside. Third, document everything you can after the stop. Write down the officer's name and badge number. Note the time, location, and circumstances of the stop. Write down exactly what was said. This documentation may be critical if the search is later challenged. Here's what this comes down to. Most drivers in Los Angeles have no idea what police can and cannot legally do during a traffic stop. That lack of knowledge is not accidental. You were not taught this in school. Your driver's license test did not cover it. And nobody volunteers this information during a stop. The result is that millions of drivers across this city consent to searches they did not have to allow. Evidence is admitted that may never have been found with proper legal justification. Cases proceed that might have been dismissed, all because of 3 seconds of uncertainty at the side of a road. Now you know what the law actually says. The question is whether you will remember it when those 3 seconds arrive. Subscribe, because next week, we are walking through exactly what happens to that evidence after an illegal search and what your rights are when the stop is over. That video goes up Thursday. Do not miss it.